albeit considering them under the same heading. The trial chamber was therefore cognizant of the fact that taking into account matters relevant to the gravity of the offense, also as aggravating circumstances for the purposes of sentencing, is not permissible. With respect to the appellant's remaining arguments, under his third ground of appeal concerning the aggravating circumstances considered by the trial chamber, namely, 1. the large number of victims, 2. the fact that the attack on Glogova was meticulously planned, 3. the appellant's abuse of authority, 4. the fact that the appellant ordered the additional torching of houses, and 5. the exacerbated vulnerability and defenselessness of the victims. The appeals chamber concludes that the trial chamber was entitled to rely upon facts related to the context of the crime in imposing its sentence, and finds that the appellant has failed to demonstrate that the trial chamber engaged in the impermissible double counting of aggravating factors. The third ground of appeal is accordingly dismissed. Finally, the appellant contends under his fourth ground of appeal that the trial chamber erred in its assessment of the mitigating circumstances. The appeals chamber notes that it has again exercised its discretion to address the merits of the appellant's argument, even though some arguments put forward in this ground of appeal impermissibly exceed the scope of his notice of appeal. On the merits, the appellant submits that the reference by the trial chamber to the negative side effects of the guilty plea shows that it expressed concerns as to the truthfulness of his admissions. The appeals chamber notes that it cannot be inferred from the part of the sentencing judgment referred to by the appellant in support of his argument that the trial chamber challenged the truthfulness of the appellant's statements. The paragraph referred to by the appellant is included in the chapeau of the section of the sentencing judgment addressing the law applicable to sentencing and contains no reference to the appellant's case. Furthermore, the appeals chamber notes that the appellant does not make any reference to the sentencing judgment in support of his argument that the trial chamber challenged his statements as untrue. As a result, the appeals chamber finds that the appellant's argument is without merit. The appellant also argues that in determining his sentence, the trial chamber only focused on deterrence and retribution and neglected to afford sufficient prominence to the process of rehabilitation. The appeals chamber notes that in citing the Celebici appeal judgment, the trial chamber correctly referred to deterrence and retribution as the main purposes of sentencing and correctly considered rehabilitation as a relevant factor that should not be given undue weight. Thus, the trial chamber did consider rehabilitation as a sentencing principle, and the fact that it decided not to give it undue weight to such a factor was within its discretion. The appellant further submits that the trial chamber erred by not considering as mitigating circumstances some facts which, in his view, showed that his character and behavior amounted to exceptional circumstances. Having carefully examined each of these facts, the appeals chamber concludes that the trial chamber committed no error. The appellant finally asserts that the trial chamber did not address at all the personal and family circumstances of the appellant as a mitigating circumstance, despite the fact that he offered substantial reasoning and presented material evidence to that effect. The appeals chamber finds that the trial chamber in fact referred expressly to the appellant's arguments regarding his family circumstances and this reference constitutes prima facie evidence that these circumstances were taken into account. The Appeals Chamber therefore concludes that the appellant has failed to show that the trial chamber committed an error that occasioned a miscarriage of justice on this point, or otherwise erred in its treatment of mitigating factors. The fourth ground of appeal is accordingly dismissed. I shall now read the operative paragraphs of the Appeals Chamber judgment on sentencing appeal. Mr. Deronjić, please, would you stand? For the foregoing reasons, the Appeals Chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the Rules of Procedure and Evidence, noting the respective written submissions of the parties and the oral arguments they presented at the hearing of 17 June 2005, sitting in open session, dismisses unanimously all the grounds of appeal filed by the appellant, affirms unanimously the sentence of 10 years imprisonment as imposed by the trial chamber, orders, in accordance with Rule 103C and Rule 107 of the rules, that the appellant is to remain in the custody of the International Tribunal pending the finalization of arrangements for his transfer to the state where his sentence will be served. The registrar, would you please deliver copies of the judgment to the parties? Mr. Deronjić, you may now be seated. The Appeals Chamber stands adjourned.
All rise for the full